Hello, this is a presentation from Rebel Law, a firm of employment lawyers who do things a bit differently. This presentation is about being put on a performance review plan. The first thing to remember is don't panic. Performance review plans don't always result in the loss of your job, but sadly, the reality is that they often do end this way. It's probably going to be a fairly stressful time and you're going to be worried about what's going to happen. If your employer thinks you're underperforming at work, they may discuss a performance review plan or performance improvement plan with you. This is used by an employer who either wants you to get better at your job, and it can go hand in hand with disciplinary action, and you may even receive a written warning at the same time. Although a performance review plan is often presented as a tool to help you, you need to bear in mind that your employer will use this process as evidence that they've followed the correct procedure if they go on to dismiss you. If you don't improve, and sometimes even if you do, they will have taken steps to cover themselves in the event of a claim for unfair dismissal. A performance review plan is a process, and at the start of it, your employer should clearly and objectively explain why they think your work isn't good enough. It should contain clear details of what improvements they expect from you. These should be measurable. It should also include a timescale for review and explain what further disciplinary action might happen if you don't make those improvements. And it should include information about what they will do to help you achieve the objectives. This might be training or support. And all of this information should be given to you at the start in writing. A performance review plan might not feel fair, and you might be shocked and surprised at receiving one. It's possible that there may be other reasons your employer is initiating this process. Some possible indicators of an unfair process include you might have had previous positive appraisals, a long period of service without any prior performance issues, or recent difficulties in your relationship with your line manager, which could indicate there might be a more personal motive for starting this process. So what can you do about it? In the first instance, you could speak to your line manager or get in touch with HR and try to resolve the issues informally. But don't hold out too much hope that this will make much of a difference, because if the problem could have been addressed informally, it's likely your line manager would have tried that first instead of putting you on this process. You can challenge the PRP if you don't agree with it by submitting a formal grievance, and check out your workplace's grievance policy for the process for doing that. You can also try appealing any disciplinary warning that you've given alongside the PRP by writing to your employer. If you are told to sign the performance review plan but you don't agree with it, you can sign in acknowledgement and add a note to the document that you've signed under pressure and which terms of the plan you do not agree with and your reasons. And here's a dose of reality from our experience as lawyers. Sadly, once an employer has decided that they don't want you in their team, they will often find a way to dismiss you. This is a good time for you to reevaluate your career goals and make sure your CV and LinkedIn profile are up to date. Looking forward is much more positive, we find. And sometimes it's better to jump before you're pushed. It could make it less stressful, less uncertain, and you get to make a dignified exit on your own terms. If you decide you're better off leaving, your employer may be willing to engage without prejudice off-the-record discussions to mutually agree your exit by signing a settlement agreement. Successful negotiations would usually result in a lump sum payment to you in compensation for the loss of your job and a reference in exchange for you waiving any future claim for unfair dismissal against the employer. You might have some post-termination restrictions you need to explore as part of this, like non-compete, for example. You will need an independent solicitor to advise you on a settlement agreement, but we recommend you get in touch with us for legal advice before you get to this stage. At Rebel Law, we are negotiation superheroes, and we're here to help talk you through your options. So, get advice, and early on if you can, from a brilliant employment lawyer like us at Rebel Law. do email us at talktoalawyer@rebel-law.co.uk. Thanks for watching.